Court calls the case of the People versus Cameron Curtis.
This is where everything begins, but don't let the calm tone fool you. What you're watching right now is the front line of the justice system, where decisions that look routine on the surface can carry serious consequences beneath. Every name being called, every short exchange, it all feeds into a much bigger process. We're entering a probable cause conference, which is essentially the court asking one critical question: is there enough evidence to move this case forward? And if the answer is yes, the next step is a preliminary examination, where things get even more serious. Now pay attention to how the defense immediately positions their argument. They highlight employment, stability, and compliance. That's not random. That's deliberate. They're building a narrative that this defendant is not a risk. Someone with a job, a home, and ties to the community is statistically less likely to flee. But here's the reality. Bond decisions are never just about stability. They're about risk versus trust. And in a moment, the prosecution is going to introduce details that challenge everything the defense just presented. So lock in, because what starts as a routine request is about to shift into something much heavier, and the judge will have to decide which version of reality carries more weight.
We are pleasingly ready in this matter, Your Honor.
Alexander, on behalf of the people.
Anna Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Cameron Curtis. Mr. Curtis, please state your name for the record.
Cameron Gage Curtis.
Your Honor, today is the date and time set for probable cause conference. We are respectfully requesting to have this matter set for a preliminary examination, and we would like to address bond briefly.
All right, all discovery is complete.
As far as we know, yes, we have all the discovery.
Preliminary examination will be set October 24th, 2023, 9 a.m. Before Judge Washington. As to bond.
Your Honor, my client is respectfully requesting that his bond be reduced to $5,010%. He does have a job in Belleville, Michigan at the Red Oak. He is employed as maintenance. He lives in Belleville. He will follow all strictures and requirements of the court. He will appear to all future court dates. He has no place to which he would flee.
Response.
Your Honor, at this time, we believe the bond is appropriate and ask that it be kept the same. In this, the victim and him had been dating on and off for 7 years. She stated that he assaulted her multiple times over the previous 3 days, and the first assault occurred when he got angry at her and she was trying to calm him down. He then strangled her by grabbing the front of her throat with his hands. She tried to get away from him. He then grabbed her hair and attempted to force her into a room. She was then able to get away and fell into the concrete as she was trying to escape. She then got into her mother's car, who just arrived, and he came up to her in the car and slapped her in the face. Officers saw injuries to her neck, face, and arms when they arrived. He also has a 2021 DV conviction, another 2021 DV conviction, and then a 2021 malicious destruction of a building misdemeanor conviction. So we believe bond is appropriate at this time.
Your Honor, my client, of course, denies the allegations in this matter. He feels that he will be vindicated at preliminary examination.
Motion for bond reduction is denied. Bond will continue.
Thank you.
Thank you.
Your Honor.
That decision came quickly, but it wasn't simple. The judge has just denied the bond reduction, and that tells you everything about how the court evaluated what was presented. Let's break this down. The defense argued stability, job, residence, compliance. But the prosecution countered with allegations of repeated violence, physical assault, and prior domestic violence convictions. And in bond hearings, prior behavior matters a lot. The judge isn't deciding guilt here. That's important. This is not a trial. Instead, the judge is asking, based on what we know right now, is it safe to reduce this person's restrictions? And clearly, the answer here was no. What stands out is how little explanation is needed. When the allegations involve multiple incidents over a short period and prior convictions exist, the court tends to lean toward caution. It's not about punishment, it's about prevention. Now here's where it gets interesting from a viewer's perspective. The defense says their client will be vindicated. The prosecution paints a pattern of violence, and the judge sides with risk management. So the question is, at this stage, before any evidence is fully tested, should the system lean more toward protecting the public or preserving the defendant's freedom?
Court calls the case, People versus Jordan Amadou.
Nimish Ganatra for the
Aye.
people.
I messed that up. Tell me. I'm
Good
doing that. I don't know.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Odumodu.
That's exactly what I said. All right. Sir, can you state your name?
Jordan Odumodu.
Okay. All right. All right. What are we doing?
Your Honor, we're asking for a brief adjournment to receive some additional discovery.
You want 1 or 2 weeks?
1 week, please.
Let's hope we have it. Probable cause conference, October 19th, 2023, 9 a.m. Bond continued. Thank you.
Thank you.
Court calls the case, People versus David Hanlon.
Your Honor, we are exceedingly ready.
Ready. He is
Send on behalf of the people.
really happy today.
Your Honor, Lauren Brown, Deputy Chief, who is really happy today, appearing with Mr. Hamlin. Mr. Hamlin, please state your name.
Yes, David Hamlin.
Thank you.
Today is the date and time set for the probable cause conference. We are respectfully requesting this matter be set for preliminary examination.
All discovery complete.
Your Honor, as far as we know, we have the discovery.
Thank you. Preliminary examination will be set in person, October 24th, 2023, 9 a.m. before Judge Barr.
Thank you, Your Honor.
Now we shift into something that looks quieter, but it's still important. This case moves forward without resistance. No arguments, no tension, no pushback. Just confirmation that discovery is complete and a preliminary examination is scheduled. This is what most cases actually look like: structured, procedural, and efficient. But don't mistake this for simplicity. What's happening here is strategic silence. Both sides already know what's coming next, and neither sees a reason to argue at this stage. That usually means one of two things. Either the case is straightforward or both sides are preparing for a bigger fight later. The preliminary examination is where the prosecution has to show probable cause in more detail. It's not a full trial, but it's the first real test of the case. And here's the key insight. Sometimes the most important moments in a case aren't loud. They're these quiet transitions where the groundwork is being set for what's coming next.
Bond continued. Thank you. Court calls the case, People versus DeAndre Davis. DeAndre Davis, need the prosecutor. Who was it? Mr. Chabalowski.
Yes, sorry, Judge. I'm
Commissioner.
Chabalowski for the people.
Assistant Public Defender Chinazi Carey. I can rule, Your Honor, on behalf of Mr. D'Andre Davis. Mr. Davis, could you state your name for the record, please?
Yes, ma'am. I'm DeAndre Davis.
Thank you. All right, what are we doing?
Judge, we're requesting an adjournment. Mr. Davis has another case that's scheduled for probable cause on the 19th. So we're asking that this date be moved to that date as well so that the people can formulate an offer relating to both cases.
So next week,
Yes.
probable cause conference without objection, October 19th, 2023, 9 a.m. Bond continued.
Thank you, Judge.
Thank you.
Mhm.
Court calls the case, People versus Deontay Brooks.
Alex Chabalowski for the people.
Good morning, Your Honor. Regina Garrett Caraher, representing Mr. Brooks. Mr. Brooks, can you state your name for the court?
Deontay Brooks. Good morning, Your Honor.
Good
Morning.
morning, sir.
And Your Honor, my apologies. I was assigned late yesterday and I was kind of stuck in court, so I did not get an opportunity to meet with Mr. Brooks, but I also do not have discovery in this matter yet. So I would be requesting an adjournment and letting Mr. Brooks know I will meet with him as soon as I can.
This moment exposes something most viewers don't think about: the human limitations inside the system. The defense attorney admits they were assigned late and haven't even met their client yet. That's not ideal, but it's reality. Public defenders often juggle multiple cases, and last-minute assignments happen more than people realize. Now, legally, proceeding without proper consultation would be a problem. The defendant has the right to understand their case, review the evidence, and work with their attorney. Without that, the process becomes unfair. So the adjournment here isn't a delay, it's a necessity. But this raises a bigger issue. If attorneys are meeting clients this late, how often does that impact outcomes? How much preparation is enough before a case moves forward? Because while the system prioritizes efficiency, justice requires preparation. And when those two collide, decisions like this become unavoidable.
No, he's out.
He's out. Okay, good enough. Probable cause conference in this case will be adjourned November 2nd, 2023, 9 a.m. Bond continued.
And Mr. Brooks, I'll put my number in the chat for you, okay? Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir. Court calls case People versus Donald Wright.
Kelly Zund on behalf of the people.
And Assistant Public Defender Emily No on behalf of Donald Reich. Mr. Reich, can you please state your name?
Donald Reich.
All right. What are we doing?
And Your Honor, we would like to address the bond violation and then set the matter for a preliminary examination.
Okay, what bond violation? Well, I'm sorry. I probably see it here.
Your Honor, I only got a report from Community Corrections. I actually haven't received the police report.
I have an October 10th bond violation indicating he was on a GPS tether, prohibited from going to 1550 East Clark Road. On October 7th at approximately 5:05 p.m., after hours monitoring received an exclusion zone alert. They attempted to contact the defendant. They did not get through to him at 5:13. They contacted Metro Dispatch to respond. At 6:01, they received a call from Simpson and advised defendant was in custody. So he was in the exclusion zone and did not respond when called, which is all part of his release on tether.
Now, this is where things get technically complex and legally interesting. We're dealing with a bond violation tied to GPS tether monitoring. On paper, it looks straightforward. The defendant entered a restricted area and didn't respond to contact attempts. That's usually enough to trigger serious consequences. But the defense introduces a different narrative. They claim this was an accident, that the defendant was shopping and the alert triggered because of how close the store was to the exclusion zone. And here's the key issue. Technology isn't perfect. GPS boundaries can be sensitive, especially in shared commercial areas. Being inside a store that overlaps with a restricted zone can trigger alerts even if there's no intent to violate conditions. So now the court has to evaluate intent versus outcome. Did the defendant knowingly violate the terms, or did the system flag something that wasn't truly a breach? That distinction matters because one suggests risk, the other suggests a technical flaw.
And Your Honor, so Mr. Reich, I did speak. That's the report I had a copy of, and I did go over that with Mr. Reich. Mr. Reich was shopping at the Dollar Tree on Ford and Holmes. This is a shopping center. He'd actually gone to that shopping center prior, since being released on the tether, but prior to the violation, to get a certified check, or a cashier's check. There was no issue. When he parked in the parking lot, there was no issue. When he went into the Dollar Tree, there was no issue. His alarm on the tether started going off when he was in the back of the Dollar Tree and like where they have their paper products. He walked back to the front, it stopped, he went home. Home being the Grand Boulevard address he was staying at, not, within the exclusion zone. When he got to the Grand Boulevard address, the police pretty much arrived right when he did. So they saw him bringing in his groceries. He gave them a receipt that was time-stamped showing that he had been shopping at the Dollar General around 5:05 p.m. It was an honest mistake. Mr. Reich knows not now that he should just not go to that shopping center. It's too close to the exclusion zone, so close that when he's in the back part of the stores, it will go off. We're asking that Your Honor reinstate his personal bond, given that this was a mistake. And I do believe if we had gotten the police reports in time, it would corroborate Mr. Reich's what happened. And for those reasons, Your Honor, we're asking for release.
Any response?
Your Honor, we would ask that bond be kept the same right now and be addressed at exams. In this case, him and the victim were in a relationship. They were hanging out and he just became upset. He then, while she was trying to grab her belongings, he grabbed her shirt collar, pulled her to the ground, was dragging her across the apartment to the kitchen, and the shirt collar was choking her. When officers arrived, they saw she had a burn mark from the shirt being pulled so hard on her neck. She was then able to
I get
escape.
all that, counsel, but the reality is he was released on a PR despite all of those alleged facts. The only issue that is keeping him in now is the alert that went off, which it is claimed that he was in the area, but it sounds like there was not an intentional violation. It sounds like he was in a store.
This is where the judge steps in, and you can immediately see the shift in tone. Instead of treating this as a clear violation, the judge starts analyzing context. That's critical, because courts don't just look at what happened, they look at why it happened. The judge acknowledges something important. If this truly was unintentional, then the situation changes completely. The purpose of bond conditions is compliance, not punishment for technical errors. And notice how both sides adjust. The prosecution still raises concerns about victim safety, but they also leave the decision to the court's discretion. That signals uncertainty. This is a gray area case, not black and white. And in these situations, judges rely heavily on reasonableness. Does the explanation make sense? Does it align with the evidence? Does it indicate future risk? Because ultimately, the court isn't just deciding what happened, it's deciding what might happen next.
If that's what it is, Your Honor, we would just ask that it be addressed at the exam.
Your Honor, Nimish
Zeppelin.
Ganatra for the people. Your Honor, Nimish Ganatra for the people. I did discuss this with Ms. Enda, and we'll leave it in the court's discretion. Obviously, we have concerns about the victim's safety, but we understand the nature of the purported violation.
Good. Thank you. Preliminary examination in this matter will be set for October 24th, 2023, 9 a.m. That is before Judge Barr. Defendant's previous, given those circumstances, previous PR bond with its conditions is reinstated. Defendant may be released.
And there it is. The decision goes in favor of the defendant. The judge reinstates the personal bond, which is a significant outcome. It means the court believes this was not a serious or intentional violation. But pay attention to the warning. Do not go to that store. That's more than advice. It's a boundary. The judge is making it clear that even if this was a mistake, there won't be much tolerance for repeat incidents. This decision reflects balance. The court acknowledges the explanation, considers the lack of intent, but still reinforces the seriousness of compliance. And this is how the system is supposed to work, evaluating not just rules, but circumstances. But here's the bigger question. Should technology-based violations carry this much weight when intent is unclear?
And sir, do not go to that store.
I certainly won't.
All right. Thank you.
Thank you, Your Honor.
Your Honor.
Thank you, Your Honor.
All right.
It's a 10,000 PR.
Thank you.
Yeah. Court calls the case of the people versus Gerald Turner.
Marie Sinsky on behalf of the people.
Good morning, Your Honor. Marcia Creech on behalf of Mr. Turner. Mr. Turner, can you please state your name?
Turner.
Your Honor, Mr. Ganatra and I are trying to resolve this case, but Mr. Ganatra has requested some mitigation information. I thereby respectfully request a 2-week adjournment so I can provide that information to Mr. Ganatra.
Without objection, probable cause October 26, 2023, 9 a.m.
Thank you, Your Honor. Have an excellent day.
I will. Bond. Court does call the cases of the people versus Jawante McFarland. All 3 cases.
Nicole Hughes on behalf of the people.
Sandra White on behalf of Jawante McFarland.
Your Honor, we are soberly ready in this matter, despite any rumors to the contrary. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. McFarland.
And Your Honor, I'm not withdrawing on this case just yet.
Oh, okay. All right, what are we doing?
Unfortunately, we are still waiting on a bed in this case. Mr. Brown and I believe, are discussing alternative placement, but haven't been successful. So we're asking for an adjournment.
That is correct.
Should I put it out 30 days and then move it up if necessary? Would that be the best option?
I think so, yeah.
I think we're set for probable cause, are we? Pardon? Probable cause. Okay. Yeah, we are. Probable cause in this matter, November 9th, 2023, 9 a.m. on all these matters. Bond will continue.
Thank you, Your Honor.
Thank you.
November 9th. Calls case of the people versus Gerard Calhoun.
Alexander on behalf of the people.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Calhoun. Mr. Calhoun, would you please state your name for the record?
First name Gerard, last name Calhoun.
Thank you. All right, what are we doing?
Your Honor, we requested some additional discovery. We're asking for a 1 or 2 week adjournment in order to be able to receive that.
Cause conference without objection, October 26, 2023, 9 a.m. Bond continue.
Your Honor.
Thank you.
Calls case people versus Montez Brooks.
Alexander on behalf of the people.
Kenneth Overwater, Assistant Public Defender, on behalf of Mr. Brooks. Mr. Brooks, please turn on your camera, unmute your device, and state your name for the record, please.
Hello?
Hello, state your name.
Montez Brooks.
Thank you, sir. All right, what are we doing?
Your Honor, I'd be asking to adjourn the probable cause conference. I've reached out to the prosecutor seeking an offer on the matter. We are still in negotiations.
Now this is where you start seeing the negotiation layer of the justice system, something most viewers never fully notice. The defense mentions they're still in discussions with the prosecutor, waiting for an offer. That means this case might not even go to a full contested hearing. Instead, it could be resolved through a plea agreement. And here's the reality: most criminal cases never reach trial. They're resolved through negotiations like this. Why? Because trials are expensive, time-consuming, and unpredictable. Both sides weigh their risks. The prosecution considers how strong their evidence is. The defense considers potential sentencing exposure. So when you hear, "we're still in negotiations," what that really means is both sides are calculating outcomes behind the scenes. But here's the key tension: negotiations create pressure. A defendant might accept a deal not because they're guilty, but because the risk of going to trial is too high. So the question becomes, is this system efficient, or does it sometimes push people into decisions they wouldn't otherwise make?
Is that the bottom? Did they see?
All
You
right.
said don't touch nothing.
November 2nd, 2023, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, Mr. Brooks. Court calls the case of the people versus Marcion Cadell.
Nimish Ganatra, First Assistant Prosecuting Attorney for the people.
Ready, Judge. Torshell Feaster, Assistant Public Defender, on behalf of Mr. Marcion Cadell. Mr. Cadell, if you're here, please unmute, turn on your camera, and state your name for the record.
Marshawn Cadell. I can't see if I'm on camera or not.
We,
Sorry.
we see you.
You are.
Okay.
All right,
Thank
what
you,
are we
Judge.
doing?
We've reached out to the number we have on screen for Mr. In our file for Mr. Cadell. We have not made any contact with him yet. We would request a 2-week adjournment and ask that Mr. Cadell please call our office.
Probable cause conference, October 26, 2023, 9 a.m. Bond will continue. Mr. Cadell,
Yes, sir.
do you have the public defender's office number?
I'm pretty sure I can get it.
Well, why don't I give it to you right now?
Oh, okay. Yeah, that'll work. Perfect.
Area code 734-222-6970.
Okay. Thank
You
you. Your
need
Honor.
to, immediately upon hanging up, you need to call that number, give them your name, give them a valid email address and a good phone number so they can contact you.
Okay. Thank you, Your Honor.
Thank you.
This moment might seem minor, but it actually reveals something critical: communication breakdown. The court is instructing the defendant to contact the public defender's office immediately. That means, up to this point, there hasn't been proper contact between the defendant and their legal representation. And that's a serious issue, because without communication, there's no strategy, no preparation, no defense. Notice how direct the judge becomes here. There's no room for delay, no tolerance for confusion. The expectation is clear: take responsibility, make contact, and move the case forward. This is one of those moments where the system shifts responsibility onto the defendant. The court can provide access, but it cannot force engagement. And here's the bigger takeaway: cases don't just depend on lawyers and judges. They depend on the defendant actively participating in their own defense. So think about this: how many outcomes are influenced not by the facts of the case, but by how well someone navigates the system itself?
Thank you, Judge.
Court calls the case, People versus Man Davis. 2 cases.
Maria Sinski on behalf of the people.
Edward Drugas on behalf of Man Davis.
Mr. Davis, can you state your name, please? Mr. Davis, can you state your name? Okay,
Davis.
thank you. All right, what are we doing?
Your Honor, I have reviewed the reports with Mr. Davis, and we're looking for a preliminary examination.
Preliminary examination. So discovery is all set?
Yes, Your Honor.
Preliminary examination in person, October 24th, 2023, 9 a.m. before Judge Washington.
Here again, we see the system moving forward without resistance. Discovery is complete, both sides are aligned, and the case is set for a preliminary examination. No arguments, no objections, just progression. But this repetition actually tells you something important. The courtroom isn't always about dramatic confrontations. In fact, most of it is about structure. Cases move through defined stages, and each stage has its own purpose. The preliminary examination is where things start to tighten. The prosecution has to show enough evidence to justify continuing the case. It's not about proving guilt beyond a reasonable doubt, but it's more than just an accusation. And when both sides are ready like this, it usually means they're confident in their positions. So even though this moment feels routine, it's setting the stage for a much more critical phase ahead.
Bond, continue.
Thank you, Your Honor.
Thank you.
Yeah. Let's call the case of the People versus Rhodesia Kennedy.
Nimish Ganatra for the people.
Assistant Public Defender Chinazi Kiriakin, Your Honor, on behalf of Ms. Kennedy. Ms. Kennedy, could you unmute and state your name for the record, please?
Rhodesia Kennedy.
Thank you, ma'am. All right, what are we doing?
Your Honor, we are asking, well, I don't know if it would be us, but we're asking for a 6 to 8 week adjournment on this case. I know that this case has been adjourned a number of times. We had been waiting for Ms. Kennedy to make a number of payments towards the balance in this case. She has made those payments. We've given proof of those payments to Mr. Ganatra in his office, and they are requesting a little bit more time before they're able to generate an offer.
Your Honor, technically the request is not at the people. We're allowing the adjournments to happen so she can make payments in hopes of a misdemeanor resolution. If the court's inclined to grant the adjournment for that purpose, then the people don't object to that. Thank you.
This situation introduces a different dynamic. Financial resolution. The defense is requesting more time so the defendant can make payments, potentially leading to a reduced charge or a more favorable outcome. And the prosecution doesn't object. That tells you everything. In some cases, especially those involving financial obligations, restitution can play a major role. If the defendant demonstrates effort to resolve the issue, like making payments, it can influence how the case is handled. But notice the judge's reaction. There's hesitation, because while the idea makes sense, there's uncertainty about timelines. How much time is enough? That's the challenge. The court has to balance fairness with efficiency. Too much delay and the process drags. Too little and the opportunity for resolution disappears. So the judge sets a firm date. This is the system trying to give a second chance while still maintaining control.
How much time is she going to need to make significant enough payments? I understand what we're trying to do here, but
I don't know, Your Honor.
well, that doesn't help me.
Doesn't at all. I know. I'm sorry.
Your Honor, my proposal.
Here's what I'll do. I'll go to November 30th. That's a date, right?
All right. Thank you. Thank you, Judge. Thank you, Mr. Ganatra.
I'll adjourn probable cause November 30th, 2023, 9 a.m. Bond continued.
Thank you, Your Honor.
You're welcome, ma'am. Court calls the case, People versus Tyrese Chambers.
On the thing until you lead him, he's right there.
Can you get Mr. Brooks? All right.
Nicole Hughes on behalf of the people.
Silvana Reed, Assistant Public Defender with and on behalf of Mr. Chambers. Mr. Chambers, could you please unmute and state your name for the record?
Tyrese Chambers.
Thank you.
Your Honor, in this matter, Mr. Chambers is going to waive to seek a prosecutor's HIDA in the circuit court.
Mr. Chambers, is that correct?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
And you understand you'll not have that hearing and you'll proceed to circuit court for further resolution. Did we lose him? Mr. Chambers, he's froze. Let me pass it briefly, see if we can contact him, get him back in.
Thank you.
Court calls the case, People versus Mary Ann Churchwell.
Nicole Hughes on behalf of the people.
Silvana Reed, Assistant Public Defender with and on behalf of Ms. Churchwell. Ms. Churchwell, could you unmute and state your name for the record?
Yes, Mary Ann Churchwell.
Thank you. Your Honor, we are going to be requesting an adjournment in this matter. I believe that her and the co-defendant are attempting to pay the remaining balance, and they're just sorting out the details of what is due and when to get that paid.
Another adjournment, but this one highlights coordination between defendants. Here, the case involves co-defendants working together to resolve financial obligations. That adds complexity, because now, progress depends on multiple people aligning their actions. If one person delays, the entire resolution can stall. And again, the court allows the adjournment. No objection. But here's the pattern becoming clear. Many of these cases are not being decided today. They're being pushed forward, delayed, adjusted. And that raises a bigger question about the system itself. How much of justice is decision-making, and how much of it is simply managing timelines? Because what we're seeing here is not just legal judgment, it's case management on a massive scale.
Without objection, probable cause in this matter will be adjourned to November 2nd, 2023, 9 a.m. Bond continued.
Thank you.
Thank you. Court calls the case, the people versus Shaquille Williams.
Jessica Blanche Craig on behalf of people.
Ready, Judge. Torshell Feaster, Assistant Public Defender on behalf of Mr. Williams. Mr. Williams, please state your name for the record. You're muted. If you can, there you go.
Bill Williams.
Thank you, Judge.
This is for competency today.
Yes, Judge.
I do have a report and have reviewed a report dated September 28th. Everybody have that report?
Yes, Your Honor.
Any additional evidence from either side?
No, Your Honor, not from the people.
No, Judge.
Everybody stipulating to the report. Court, upon reviewing that report, would find that the defendant is competent to stand trial. Specifically, the court would find that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. Mr. Feaster, I would need an order sent over, please.
Okay, I'll prepare that.
Mr. Feaster, just so you know, Emmons already prepared one, so he'll send it to you for your
Thank
review.
you. Thank you, Mr. Emmons. Thank you, Ms. Blanche. Judge,
It's so nice when you guys play well together. Go ahead.
Thank you, Judge. We can set it for another PCC date. I think we are still waiting on criminal responsibility, and I think that might impact the offer in this file. So if we could adjourn it for a couple or 3 weeks, please.
Couple or three, you said?
Yes, please.
Probable cause November 2nd, 2023, 9 a.m.
Thank you, Judge.
Bond continued. Thank you.
Thank you, Ms. Blanche.
Thank you.
I think Mr. Chambers came back. Let me get these custodies out. Court calls case People versus Christopher Fisher.
Nicole Hughes on behalf of the people.
Christopher Fisher, I got him.
Yes, sir.
Yes, I see you. I'm waiting for your attorney. Miss Iconrulli.
I am so sorry, Your Honor. Assistant Public Defender Chinazi Kiriakin on behalf of Mr. Christopher Fisher. Mr. Fisher, could you state your name for the record, please?
Christopher Jason Fisher.
Thank you, sir. All right, what are we doing?
Your Honor, we are asking for an adjournment in this matter. We are still in communication with the prosecution, and they've yet to make an offer, but they're working on something. So we're just asking for the time.
2 weeks or 3?
Ms. Hughes,
2 weeks, please.
3.
Sure.
Probable cause conference November 2nd, without objection, 2023, 9 a.m. Bond continued. All right.
Thank you, Your Honor.
Thank you, Mr. Fisher. Court calls the case People versus Larry Morris.
Reinstates on behalf of the people.
Good morning, Your Honor. Regina Garrett Carrer on behalf of Mr. Morris. Mr. Morris, can you state your name for the court?
Larry Morris.
And Your Honor, today's the time set for a probable cause conference in this matter. I've reached out to Mr. Ganatra regarding getting an offer. Ms. Ruzinski, I think you were copied on that email as well. And I believe they need to speak with confirm whatever it would be with the victim first. So we would need an adjournment so we can get that and I can discuss it with my client.
1 or 2 weeks?
Ms. Ruzinski, what do you think?
2 weeks, please, Your Honor.
Probable cause conference without objection, October 26, 2023, 9 a.m. Bond continued. Thank you.
Thank you, Your Honor. Thank you, Ms. Ruzinski, and everyone have a great day.
Thank you.
Court calls the case People versus Isaiah Gillespie.
Alexander on behalf of the people.
Kenneth Overwater, Assistant Public Defender on behalf of Mr. Gillespie. Your Honor, I am dubiously ready to proceed.
Okay. Mr. Gillespie, can you state your name, please?
Isaiah Gillespie.
All right. What are we doing then?
Your Honor, I do not have the police reports in on base. I don't know if this is a technical issue on our office's part, but I have not had the opportunity to review them or discuss them with Mr. Gillespie. He is held on other matters. I would ask to adjourn the probable cause conference 1 week.
Probable cause conference will be adjourned October 19th, 2023, 9 a.m. Bond continued. Thank you.
Thank you, Your Honor.
Court recalls the case of People versus Tyrese Chambers.
Silvana
Use on
Reed,
behalf of the people.
Silvana Reed, Assistant Public Defender with and on behalf of Mr. Chambers. Mr. Chambers, could you state your name again for the record?
Seriously.
Yeah, I mean, he's back.
He's back, but he's. Can we shut his video?
I'm sorry. It's
Okay. No, we shut your video, Mr. Chambers. We got bandwidth. So, Mr. Chambers.
Yes, sir.
All right. So you do understand you're waiving your preliminary examination and that the proceedings will occur in circuit court. That's where to be resolved. You understand that?
Yes, sir.
People also waive their right.
Yes, Your Honor, we do. And just to be clear for the record, this is a straight waiver. There has been no offer of Prosecutor Haida. There has been no guarantee that he will receive it in circuit court. I understand that that's a conversation they would like to have with the circuit court prosecutor.
All right. Preliminary examination having been waived, defendant is bound over to circuit court on a single count. Ms. Reed.
This is a major transition point. The defendant has waived the preliminary examination, and the case is now moving to circuit court. Let's break that down. By waiving the preliminary exam, the defendant is essentially choosing not to challenge probable cause at this stage. That doesn't mean they're admitting guilt. It just means they're skipping this step. Why would someone do that? Strategy. Sometimes the defense believes it's better to move directly to a higher court, where negotiations or trial preparation can happen under different conditions. But notice what the court clarifies. There is no guaranteed deal, no promises. That's important, because once you waive this step, you lose the opportunity to test the prosecution's evidence early. So this is a calculated risk. And now, the case moves into a more serious phase, where the stakes are even higher.
We would waive a formal reading and stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
December 5th at 1:30 p.m. with Judge Conkey.
December 5th, 2023, 1:30, Judge Conkey.
Thank you.
Bond continued.
Thank you, Judge. You have a good day.
You do the same, sir.
What you've just watched is a full snapshot of how the justice system operates. Not in theory, but in real time. Multiple cases, different circumstances, but the same underlying structure. Evaluation, adjustment, progression. Some defendants asked for reduced bonds and were denied. Others faced violations and were given another chance. Some cases moved forward quickly, while others were delayed for preparation, negotiation, or logistical reasons. And that's the key takeaway. Justice is not a single moment. It's a process shaped by evidence, strategy, timing, and human judgment. Judge Simpson's role throughout this session reflects that balance. Firm when necessary, flexible when appropriate, and always focused on maintaining order within the system. But here's the bigger picture. Every decision here, whether it's a denied bond, an adjournment, or a case moving forward, has real consequences for the people involved. Lives don't pause just because a case is pending. So now it comes down to you. Based on everything you've seen, do you think the system handled these situations fairly? Or are there moments where things should have gone differently? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.